LLC et al. And related claims. Let me try to take the appearances in a somewhat orderly fashion. We'll start with the plaintiff and NBD.
Good morning, Your Honor. Jesse Callahan and Kathleen Schaefer on behalf of NBD.
Good morning. I'll take the appearance for the defendants, Jim Christopher Arnold and Stacy Arnold, and the related entities.
Good morning, Your Honor. Susie Ingold, Jake Curtis, and Aaron Duell on behalf of the Arnold defendants, UCI and AFG. As Your Honor also noted, defendant Stacy Arnold is also appearing.
Good morning. I'll take the appearance for the receiver.
Good morning, Your Honor. Michael Jones, Alan Jones, and Giles for the receiver.
Good morning. I'll take the appearance for the ATX parties.
Good morning, Your Honor. John Krager, Michelle Buckley, and Blaze Bowles on behalf of ATX.
Good morning. I'll take the appearance for, I believe we have somebody for Christopher Arnold and Alexander Arnold.
Yes. Good morning, Your Honor. Brian Foster for Christopher Arnold and Alexander Arnold.
Good morning. I believe those are all the people I saw on the screen, but let me ask, are there any other appearances for anybody I missed? Okay, hearing none. This is the time set for a trial setting conference, and we have a number of motions pending, many of which are not yet at issue, and we have oral argument set on some of those motions. I'm also going to address, though, two motions that have been filed, two motions to seal that I want to address while we're all together today. But let's start with the trial setting and find out if we're ready to set a trial date. I think because we didn't have information in a joint report, because the way this case started, there wasn't a joint report, I guess, preceding the appointment of the receiver. I think my staff reached out to find out how much time the parties were going to need for a jury trial, and the report back that I received was 14 to 15 days. And I do note that there was a private mediation deadline in the last scheduling order of July 31, 2026. So I want to find out whether that was complied with. So Mr. Callahan, you're the plaintiff. We'll start with you.
Thank you, Your Honor. I believe the parties are ready to set the trial. In terms of the mediation, there's been multiple mediation deadlines. We have tried to schedule the mediation. We've suggested mediators. We've asked for input from the Arnold camp on who the mediators are that they would like to use. And unfortunately, we just get crickets in response. There's been no agreement to the mediators we proposed. There's been no response when we asked what mediators would you guys use. And we even stipulated to extend the deadline. And when we did that, we said, we received no cooperation before, so we're happy to extend this deadline, but are we actually going to participate in a mediation this time? And they said yes, but then we just never scheduled one. So it's strange. I don't encounter that very often. But to answer Your Honor's questions, no, we're unable to meet the mediation deadline because the defendants didn't cooperate in scheduling it.
Okay, besides, well, before I move on to other questions, I am going to require a mediation before we have a trial. I may set a trial date so that we don't lose time today, but I likely will vacate that trial date if the parties don't participate in good faith in a mediation. I'm not going to take a 3.5 week time setting for a trial and not have the parties try to mediate to resolve that. That's a substantial burden on the court's calendar to put that big of a block on there. So I'm going to require a mediation. So are you in agreement, Mr. Callahan, that you think this is going to be a 14 to 15 day trial?
Yes, Your Honor, 14 days is what we suggested. That may be impacted by rulings on the dispositive motion, but as it stands, it's a long history. There's a lot to address with the jury. And our thought is 14 days is a reasonable trial setting in a case like this with what's at stake.
And besides completing a mediation and having the argument on the dispositive motions and having those ruled on, what else needs to be done to prepare the case for trial?
I think those are the two things, Your Honor, and then, we'll go forward with our motions in limine. There's one other issue. There's a third-party complaint that was filed by the Arnold camp. It was never served or prosecuted. I believe they were going to dismiss that, and it hasn't. But those are things we can clean up. But the substantive issues are we would need rulings on the dispositive motions, and we would need to mediate in advance of the trial. Those are the two things, Your Honor.
Okay, Ms. Ingold?
Thank you, Your Honor. As to mediation, the defendants absolutely agree that we should and will complete mediation before trial in this case. We've made that clear to plaintiff's counsel as well. The intervening issues really relate to the bulk of the pending motions for summary judgment that were pushed back at plaintiff's counsel's request. The deadline for those motions, as well as overall discovery, was extended. So the bottom line is this is not overly complicated. It's just a simple fact of deadlines being pushed back and the realistic possibilities for successful mediation while all those motions were pending. So we appreciate Your Honor's agreement to set the trial dates today. We understand the burden that would impose should moving parts continue moving, but we don't believe that will be the case. We believe that we will be able to participate and complete mediation and move towards a trial date should that be necessary, which we believe it likely will be. And as to the number of trial days, we agree 14 to 15 days. And we are, again, prepared to set the trial today. Your Honor, we do have a question, just simply logistics about Your Honor's trial calendar days, and whether Your Honor holds trial Monday through Friday, or if it's more like a Tuesday through Friday situation.
We'll address that in just a moment when I talk about trial days, but we do a Monday through Thursday trial calendar.
Thank you.
So do you agree with Mr. Callahan's position as to what needs to be done to prepare for trial, just the mediation and the resolution of the pending dispositive motions?
Yes, Your Honor.
Okay. Before I move on to other parties, I see on my notes here that we have oral argument on some motions for summary judgment and other motions on September 18. I'm going to want an update from the parties as to where we are on mediation at that hearing. And if I'm not satisfied with the answers I'm getting, any trial setting that I make today may be vacated at that hearing. So I want to see progress towards having the mediation completed. Okay, Mr. Jones, does the receiver have any position on trial setting, anything along those lines?
No, Your Honor. The receiver is not a party to that the litigation here, and we're here to observe and answer any questions the judge has. So.
Okay. Are there any other parties who want to weigh in on a trial setting? And by parties, I should say that I'm using that term broadly. Okay, I don't hear anybody else who wants to weigh in. So for a trial of that length, we're really talking about having to push that out. That's why I'm going to go ahead and set it today. That's a pretty long trial to set. And so I'm probably looking at setting that in the middle of September 2027 to have that long of a trial. So we're looking at September 14, 2027 through October 7, 2027. That would be 15 days if I'm just counting the Mondays through Thursdays. We have Friday as our law in motion day. So Let me ask you, Mr. Callahan, does that time period work for you?
Yes, it does. Thank you, Your Honor.
Ms. Ingold?
Yes, Your Honor, September 14th through October 2nd,
October 7th.
7th.
Okay, so the Mondays through Thursdays during that time period. That'll be our trial setting. And the first day of trial will start at 9 o'clock a.m. The remaining days of trial will start at 9:30. And our typical trial day goes to 4:30. We take the lunch recess from noon to 1:30, and we'll have a 15-minute mid-morning recess and mid-afternoon recess. We're looking at setting the final trial management conference. Of course, the trial will be in person, so will the final trial management conference. And we're looking to set that on August 13, 2027 at 1:30 p.m. That would be an in-person hearing. Usually that takes about an hour. We won't set anything else that afternoon just in case we run over. It could in a case like this. So how does August 13, 2027 at 1:30 look for you, Mr. Callahan?
That works for plaintiff. Thank you.
Ms. Ingold?
Yes, Your Honor, thank you.
Okay, and we need to set what we call a preliminary voir dire hearing. We do a jury questionnaire, and we do that digitally, and we send that out to the jurors in advance so that they can complete that without necessarily having to come down to the court and perhaps be excused from jury service. So it's a convenience to the jurors. It also helps us expedite the jury selection process on the first day of trial. We can do that virtually. We usually take about an hour to go through the questionnaires that have been submitted in advance. And we're looking to set that on September 13, 2027 at 11 o'clock a.m. Does that date and time work for you, Mr. Callahan?
Yes, Your Honor. Thank you.
Ms. Ingold, does that work for you?
Yes.
Okay, now we will, on the final trial management conference, as I've said, that's in person. You will get an invitation to a Teams meeting like this, like you did for this virtual hearing. And the only reason for that is because we live stream all of our proceedings. And so in order for us to live stream, there has to be a Teams invitation that goes out. Don't think that I decided to make that a virtual hearing. It is an in-person hearing. The minute entry from today's hearing will also contain the other dates that correspond with this trial setting, and those dates will include things for like submitting exhibits, filing the joint pretrial statement, filing motions in limine, submitting questions for the juror questionnaire, proposed jury instructions, etc. So all of those dates will be set out in the minute entry. We do operate pretty much paperless in this division, so all of the exhibits, as will be explained in the minute entry, will need to be uploaded digitally to the Case Center platform. I don't require paper copies of the exhibits. I imagine there'll be a lot of exhibits and we don't need to waste all that paper, but we'll talk more about that too at the final trial management conference. So any questions about the trial setting, any issues related to that, Mr. Callahan?
None from plaintiff. Thank you.
Ms. Ingold?
No, Your Honor, thank you.
Anybody else? Okay, I don't hear any other questions. Let me turn to the motions to seal. I have one that was filed by the plaintiff. It seems like I guess I'll call it a reluctant motion to seal. It's to seal motions or exhibits, some of the exhibits attached to plaintiff's statement of fact. Mr. Callahan, I gather from the motion that you don't necessarily believe that those documents are documents that need to be filed under seal, but they were designated by the defendants as confidential documents under the protective order. I didn't see a response to that. Is that essentially your position, Mr. Callahan?
Yes, Your Honor, they were designated as confidential by the Arnold defendants, and so we're honoring that designation.
Okay. I looked at the exhibits. They seem to be just transaction documents, agreements, and they don't strike me as documents, at least in their entirety, that meet the qualifications for being filed under seal under Rule 5.4. And I take my obligations under Rule 5.4 seriously, and I'm a firm believer in open courts and public access to court documents and transparency of what we do in the courts. And there obviously are times that documents need to be filed under seal, but I'm not seeing it here, and and maybe parts of those documents need to be filed under seal if there are references to amounts in certain transactions or what have you. But the form of order that was submitted also doesn't comply with Rule 5.4. 5.4 requires certain findings to be made in the order, and the proposed form of order doesn't comply with that. So on that motion to seal, I'm going to deny it without prejudice. And perhaps, Mr. Callahan, you and Ms. Ingold need to confer to see what really needs to be sealed, if any of those exhibits. And so I'll give you an opportunity to do that and resubmit. And if there's a belief that portions of those need to be filed under seal, I'm going to require a proposed form of order that complies with Rule 5.4.
Thank you, Your Honor. We appreciate that. We would observe, I think, at least one of the documents that the Arnolds designated as confidential that we sought to file under seal, they actually included with their dispositive motion. So hopefully we can just refile this in full form without any of the redactions, but we will confer with Arnold's counsel and see if we can reach an agreement on that.
Okay, very good. Let me turn to the receiver's unopposed motion to file the receiver's report for May through June, partially under seal. And I've dealt with some of those before, Mr. Jones, and I appreciate the need to redact, and I'll approve that, the request to redact certain portions of the receiver's report. But again, the proposed form of order doesn't contain the necessary findings under Rule 5.4, so I'm going to require you to submit a compliant form of order so that I don't have to draft one on my own.
We will. Thank you, Your Honor.
Okay, so I'll hold that one. When you submit that, email that proposed order to my staff, and they'll get that to me in e-file so I can sign off on that.
We will.
Okay.
Thank you.
Are there any other issues that we need to address today, Mr. Callahan?
Your Honor, one housekeeping matter. We filed dispositive motions at the same time as the Arnolds, and we inadvertently did not include a request for oral argument in our caption. And so the oral argument as set doesn't include NBD's motion, but the issues do overlap and interrelate, and we have filed a supplemental request for oral argument on our motion. And if all those motions are argued, we might need to expand that hour. And
Yeah, let me take a look at the hearing. Hold on. Let me take a look at our calendar that day. Okay, so we have that at 9 o'clock, and I have another oral argument at 11 o'clock. If I just block that 2 hours, does that give us enough time to set all of the dispositive motions for oral argument at that time, Mr. Callahan?
From our perspective, yes, Your Honor. Thank you so much.
Okay. Does anybody disagree and think that 2 hours is insufficient?
No, Your Honor, defendants agree that that should be sufficient.
Okay, so what I'm going to do is, to the extent there are dispositive motions that have been filed that were not included in the oral argument setting, I'm going to set all of those dispositive motions. So my staff will go through and figure out which ones those are, and we'll include that in the minute entry so that I'm setting oral argument on all of the pending dispositive motions. Okay, other than that, Mr. Callahan, anything further from you?
Nothing further. Thank you, Your Honor.
Ms. Ingold?
No, thank you, Your Honor.
Okay, anybody else? Okay, thank you, everybody. Have a good day.
Thank you.
This is CV 2026-014431, Cringen versus Cundiff et al. And related claims. I'll take the appearance for the plaintiff, please.
Good morning, Your Honor. Lawrence Pallas on behalf of plaintiffs Michael and Carla Cringen, and as mentioned a moment ago, their daughter Cabrina is on the line.
Good morning. I'll take the appearance for defendant Fusion Orthopedics.
Your Honor, Steve Mahaffey representing Fusion Orthopedics, LLC.
Good morning, and I'll take the appearance for the remaining defendants.
Brian Holohan, Your Honor.
Good morning. This is the time. This is the time set for a Rule 16 conference that was set at the plaintiff's request. It sounds like there's some difficulty trying to get a joint report and proposed scheduling order submitted to the court. Mr. Pallas.
Yes, Your Honor. We did do a meet and confer. It was the defendant's position that they were not amenable to doing any discovery of any kind prior to the court entering, having this conference and the court entering a scheduling order. And until they filed their proposed joint report and scheduling order, did not respond to our dates or anything. But I more than that, I think the important thing is, given the compressed time frame, getting these deadlines set so that we can conduct the necessary discovery for this hearing in October. As I read their version of it, they would not have any deadlines for discovery before the hearing with respect to written discovery at any rate, or depositions. And so, we proposed a schedule. A few of the dates in that proposed joint report and scheduling order passed at the turn of the month. And I have some revised proposed dates if the court would like, if that would be of assistance. But I think, it's our position, and I believe that the court had indicated that it was contemplating some discovery prior to this hearing, this evidentiary hearing. And so there's, time is passing.
Okay, who wants to go first, Mr. Mahaffey or Mr. Holohan?
Judge, perhaps I should. I'm the one, I think, who caused the controversy.
Okay.
I am not opposed to discovery before the hearing. The objection that I initially had to the plaintiff's proposed scheduling order is that it set up what I viewed to be a two-tier discovery track, which I thought was unnecessary. Later, I sent an email to Mr. Jess that said, upon reflection, you're right, there needs to be some deadlines before the hearing. And I proposed, for example, a deadline if someone intends to call an expert, that expert has to be disclosed by a date certain. I don't see a need to have other deadlines. And our version of the proposed scheduling order also changed how deadlines are set. We offered dates certain rather than X number of days from such and such an event.
And that's what the rule contemplates.
That's been my experience, Judge. That's the reason I did that. When I returned it to Mr. Jess, I got a terse email essentially refusing to do anything more because, well, as he phrased it, for the avoidance of doubt, we don't agree with your changes. And then that ended the matter, apparently.
Okay. Mr. Mahaffey, do you have anything to add?
Your Honor, only that my recollection of that meet and confer was that plaintiffs were unwilling to agree that any depositions or any discovery done prior to the receivership hearing didn't count against the overall amount. And we believe that the numbers are set and you can use them however you want. But if you use them, then they're done. And so there, I think Mr. Holohan mentioned the dual track, and that's one of the things we objected to.
Okay, let me go back to Mr. Pallas. What discovery are you wanting to do before the evidentiary hearing?
Well, I think we need some written discovery, and particularly that would be requests for production of documents. What we really need are the financials, and it's my belief that those should be easily accessed and able to be turned over, given that it's going to be the same materials that presumably were gathered, disclosed, and used as some of them used as trial exhibits in the Schilling case back in March and April. As far as depositions, I would think deposition of any expert, and then perhaps the two principals in the two defendant principals. I guess that would be the first cut at it, and then given the time constraints and the fact that we only have a 3-day hearing, that would probably be more than enough.
Okay. Well, it sounds like the defendants are in agreement that there should be discovery permitted before the evidentiary hearing, and I certainly would expect that, so that we're not doing discovery on the fly, so to speak, during a 3-day hearing. I would like an efficient use of the court's time at that hearing. So do you take the position, Mr. Pallas, that the request for production that you are seeking to propound, that those should not count towards your number of written discovery requests?
Your Honor, I mean, I can make an argument for it, but if that is the subject of some resistance, and we get to a point later in the case where it's apparent that we feel the need for additional requests, then we could petition the court for that, if that eliminates that issue here.
I think it does, because it seems like what you're requesting would be something that you'd be requesting for the case if we weren't having this evidentiary hearing. So from that standpoint, it seems to me that the request should count toward the number. And if, as the litigation progresses, you think that there's cause to exceed the number, the presumptive number under the rules, you meet and confer, and if you can't agree, then presumably somebody's going to file a Rule 26D statement or somehow bring it before the court, and then I'll resolve the issue.
I could tell you what the concern I have, and it's somewhat with respect to this particular issue, but in general, and that is, given how little time we have, that we're going to run into a bunch of discovery disputes about this stuff before the hearing. And the reason why the requests for production are so important is that the defendants seem to seek to very narrowly, define in their submission what is required to be disclosed prior to the hearing, or they may have a date certain in there, and that's effectively the documents or witnesses that a party plans to use at the hearing based on what they know at the time. And I think we need discovery and are entitled to certainly financial records beyond what the defendants may intend to introduce at that 3-day hearing. And so, but again, this is, if we need to, or if we feel the need to send more discovery requests, then we can go through the discovery process as you just outlined.
Okay. What about depositions and the expert disclosures? Do I need to set some deadlines today for when any expert who's going to be used at the evidentiary hearing needs to be disclosed with their written opinion, and then set deadlines for any depositions, or is that something that you can work out?
Well, we have proposed dates. I think they have proposed dates with respect to the expert. But I do think that, Your Honor, deadlines are going to be helpful to us and will eliminate any confusion or opportunity for there to be disagreements. And so I would ask for deadlines, along those lines.
Okay, what do you propose for an expert disclosure deadline?
All right, let me get to my.
Larry, I think you're on mute. Larry, you're on mute.
Pilot error, I apologize. Areas of expert testimony, we had proposed July 17th, and we suggest moving it to August 14th. That's just the areas. Expert reports to September 11th from August 15th, and rebuttal reports September 28th.
Okay, do those dates work for you, Mr. Holohan?
If I heard him correctly, those are dates further out than we had proposed in our draft order. So yes, those are fine.
Okay, and Mr. Mahaffey, what about you?
I believe that we can work within those, Your Honor. Certainly the 14th, we can get him areas, this report by the 11th, September 11th. Yeah, I mean, we'll just have to make that happen, Your Honor. I know we're kind of clamped for time, so.
Okay, then I'm going to adopt those deadlines for the expert disclosures. Do we need to have a deadline for completing depositions of the experts who are going to be testifying at the evidentiary hearing?
And I believe the deposition deadline that we would propose, we had September 30th. I don't think we have a lot of time, so we could push it to October 2nd. That's Friday to Monday. I don't know that helps anyone. But the hearing is coming up pretty quickly after that. That's on the 21st, so.
Okay, what's your view on the deadline for expert depositions, Mr. Holohan?
Judge, it would be my preference not to have a deadline. Given the compressed time limit, it may be because of scheduling that we have to take a deposition a week or 10 days before the hearing, and a deadline clogs up that potential process.
I would concur with that, Your Honor. I think we're clear that they're going to get to take a deposition. So I don't think we're going to, object to it and push it out. Obviously, we'd be back in front of you in a heartbeat. So I think without a deadline or one maybe a few days before the hearing.
Okay. See, we start the hearing on is it the 20th?
October 20th.
I believe, Your Honor.
Okay, so let me, because you're going to, I know you'll get expedited transcripts, but I'm going to set the deadline as October 13, 2026, so that you can get transcripts so that you can use the depositions in connection with the evidentiary hearings. So hopefully you get the deposition set before then, but October 13 will be the deadline for completing the expert depositions. So what other?
Is that all depositions, Your Honor? Is that all depositions or just expert?
Are you envisioning non-expert depositions prior to the evidentiary hearing?
I thought
Yes,
I
Your
heard
Honor.
Mr. Palace say that, yeah.
Okay, then let's set that deadline for completing all depositions. And obviously it behooves you not to schedule them all on, the last few days before that. So, let's not make a log jam. Hopefully you can work in good faith to schedule those so that you can get them done and get the transcripts prepared. So did I imagine I previously set a deadline for uploading the exhibits into Case Center, didn't I?
You did, yes.
That's
You did.
all in your order, Your Honor. Yes.
Okay, so, so I don't need to set that. Do we need to have deadlines for propounding any, written discovery?
It would be helpful, Your Honor, and certainly for discovery responses.
Okay, so, when do you propose to have written discovery propounded? A deadline for propounding written discovery that's going to give enough time to, get responses? And I imagine you want those before you have the deposition. So, so what do you propose? How quickly can you get your discovery requests out?
Well, I propose a deadline of August 14th. I'm anticipate getting our requests out before then, but that would be my proposal for a deadline.
Okay, can the defendants live with August 14th as a deadline for propounding any written discovery?
Judge, I would prefer pushing it back to the 24th. Wilson is out of the country and won't be back. And it's his client, his case, and I'd certainly like him to be involved in the process. And I'm not sure I'll be able to do it by the 14th. And as it is, I have a trial starting that day, so it would be my preference to get a little extra time to accommodate both Don's and my schedule.
Okay, if I
Your
push
Honor.
it, oh, go ahead.
I'm sorry, Your Honor. I'm out of state August 14 through 24. So my preference would be August 28 as the deadline for propounding.
Well, if I push it that far, and obviously you can propound written discovery before you go, but if I push it to the 28th, and let me.
Yeah, I know. You're right. Yep.
So now how much time do you think you need? Because I'm going to order expedited responses to written discovery. I have to make the schedule work. So if I put that as August 28th is the deadline to propound, can we have responses 2 weeks after the discovery is propounded?
What my proposal was going to be September 11th, but that was based on a propounding of August 14th, but that didn't account for expedited responses. If we're doing these depositions, I mean, there's tension on both sides of the thing, and I just tried to back out from the hearing date depositions and those final deadlines. We will operate within the dates that you set, Your Honor. But my proposal was to propound it quickly, and I didn't think that was as heavy a lift as responding is, and then a response around the 11th or maybe 14th of September.
Okay, if I understand people's calendars being out of town and Mr. Wilson being out of town and being involved. So if I'll set the deadline for propounding written discovery as August 28, 2026. And if I then set the deadline for responding is September 18. Does that give everybody enough time to digest what you're going to be getting and prepare for depositions?
It does for us, Your Honor.
We'll make it work.
As long as my concern is that we end up at or about the 18th with a bunch of objections rather than
I'll address that in a moment. Okay.
But
So
to answer your question in light of that, assuming we get the materials, once again, we will make it work.
okay. So the deadline, the expedited deadline for responding to written discovery will be September 18, 2026. And let me just address that concern. There's not going to be a lot of time for discovery disputes. And I'll tell you, I'm trying to decide how to word this. It's not that I'm not a big fan of, I don't tolerate boilerplate objections. And I'll just put everybody on notice that my approach on discovery is that the scope of discovery, I interpret that broadly. We're not talking about admissibility of evidence. We're talking about the scope of discovery. So just because something may not be relevant for the hearing doesn't necessarily mean that it's not within the scope of discovery. Now, having said that, I'm directing the parties to tailor this expedited discovery to what's needed for the evidentiary hearing. You're going to have an opportunity to take broader discovery after that. And what I'm trying to do by giving you my philosophy on discovery is to head off any unnecessary discovery disputes and unnecessary objections to discovery requests. Any questions about that?
Understood, Your Honor. Thank you.
Okay,
Thank you, Your Honor. I understand. And I have one other matter if we're done with this.
Okay, go ahead, Mr. Mahaffey.
Your Honor, the plaintiffs have issued a subpoena to the expert in the Schelling case, and they've subpoenaed his expert report. Those reports are subject to a protection order in the Schelling case. That protection order is still in place. And I was preparing a motion to quash, but Mr. Pallas informed me they haven't served it yet. So I've held up on it. But I thought, while we're here, if that's something the court wants to address, I think that would be helpful for both of us. Otherwise, when they serve it, I can file a motion to quash, and we can bring it up then.
Okay, Mr. Pallas, what's going on with that? And I know there's another case, the Schilling case. I'm not familiar with it. I don't know who has that case and who the parties are to that.
I can answer those questions if you want, Your Honor.
Go ahead very briefly, Mr. Mahaffey.
Yeah, Judge David McDowell is the judge. The parties are Craig Schelling and Fusion Orthopedics and Fusion Orthopedics USA. And then there's cross claims.
Okay. So Mr. Pallas, what about the subpoena, and do you have to go get relief from Judge McDowell if there's a protective order there? How do you think we resolve this?
Well, Your Honor, I can speak generally to this. This has somebody else was handling it, but my understanding is that his report has some bearing on the transfers and the nature of them. I've not seen it if it's subject to a protective order, but it does sound like, you know, we may need relief if it is subject to the order, and we're certainly willing to enter into whatever sort of protective order you know, that's consistent with that. In this case, I think I've answered your question.
Okay. I'll just tell you, and I just have a couple minutes left because I have a 10 o'clock hearing, but I can't make a decision on what to do with that subpoena. It seems like there's not a basis to quash the subpoena because it hasn't been served yet, but I don't know that I can give you permission to get it, Mr. Pallas. You may have to go into that other case, and if there's a protective order there, and confer with those parties and see if you can get permission, and ultimately, if there's a dispute about the protective order in that case, you might have to take that up with Judge McDowell.
Understood. Thank you.
Okay. Anything else briefly before we sign off?
I have one thing, Judge.
Oh, go ahead.
Go ahead, Mr. Hollihan.
We were working on a protective order regarding document production, and we were very close. We seem to have one snag, and it's the obligations of experts and consultants who receive documents that are protected under the order. The primary dispute is whether the experts will be under an obligation to return them. I propose language that as long as Mr. Jess and Mr. Pallas certify that they were destroyed, that would be good enough. But around the same time, they went dark on the scheduling order, and they went dark on the confidentiality order. So perhaps a little guidance from you on whether you think it's appropriate for experts to have to either return the documents. Well, ideally, I'd like to have them returned. It's the only way I can be sure that some expert didn't keep copies of it. But I was prepared.
Very briefly, because we need to wrap up, Mr. Pallas, what's going on that issue?
Your Honor, I apologize, but I haven't been involved. I can tell you that it seems like something that we should be able to work out. Perhaps what the snag was is whatever the termination of discussions on the other issue is. It just never got discussed, but I will look into it.
Okay, and I'll give you my view that it seems appropriate once the litigation is done and the expert no longer has a need for that. If there are confidential documents, those ought to be returned, or if not returned, destroyed with the certification that they've been destroyed. One of those two ought to take place.
I don't think we were ever going to dispute that. I don't know if there was any other issue that somebody else had, but I appreciate you sharing that guidance.
Okay, very good. Thank you, everybody. We'll wrap up now. Thank you.
Thank you, Your Honor.
Thank you.
This is CV 2022-092-214 Astraveda Corporation et al. Versus Disruptive Resources LLC et al. I'll take the appearance for the plaintiffs, please.
Good morning, Your Honor. Scott F. Gibson for the plaintiffs.
Good morning. I'll take the appearance for the defendants.
Michael Marion for the defendants, Your Honor.
Good morning. This is the time set for a trial scheduling conference that was requested by the plaintiffs. So I want to find out where we are in terms of any ADR mediation, what's taken place, what kind of settlement conference has been conducted, and find out how much time you think you need for the trial. I think the joint report had estimated 4 days. So let me start with you, Mr. Gibson.
Thank you, Your Honor. The parties had a mediation. When was that, Mike? It's been a while ago. I think earlier this year.
I think it's been a year. I think it was September last year, actually, at this point.
And there are multiple causes pending between these parties, and so that was a global mediation attempt, which was unsuccessful, with done with the assistance of Maria Speth here locally.
Okay.
And in terms of trial, I think 4 days is appropriate. I think we can. I always try to get done in less, but I think 4 days is not an unreasonable request.
Okay. And what else needs to be done to prepare for trial, if anything? And when would you be ready to go to trial?
The discovery is completed. We have submitted a motion for reconsideration to you about a week and a half ago.
I'm aware of that.
Okay. From our end, there's nothing else remaining. We could be ready as early as end of the year.
Okay. I'm not going to be able to get you in before the end of the year, but let me hear from Mr. Marion on his views about the trial length and when he thinks trial ought to be set and what else needs to be done.
Yes, Your Honor. So I think starting with, let's take these in order. So starting with trial length, I think we're in agreement that probably 4 days for trial is still going to be probably the right estimate, that although summary judgment removed a few issues, a lot of the same evidence still needs to be presented regardless of those disputes being resolved. So I think the 4 day estimate is probably still the right amount of time for that. In terms of ADR, I want to actually go back and say that it was actually September 2024. So the parties haven't really talked settlement in almost 2 years. And as Mr. Gibson said, that there are other matters. There's a matter in Delaware pending as well involving the parties. There is a claim construction hearing for the patents at issue. It's on this Friday. So I'm not sure if it makes sense for us to get that order, because things may crystallize a little bit in terms of that part of what's going on. And there may be an opportunity for further discussions, since, again, the parties really have not had any discussions for settlement in the last 2 years, and a lot has happened since then. So whether or not there will be further opportunity, whether or not the parties actually will do that, I can't speak to, what the outcome of that particular decision will be, or where the plaintiffs are in terms of wanting to approach that. But I think that may be useful in making some guidance, giving at least some leeway and some time to having those discussions if the parties think that it would be useful at that point. So I think at least scheduling to a point where that is permissible, and it sounds like we're going to have that time regardless based on your calendar. That makes the most sense here. So, in terms of what we need to get ready for trial, discovery in terms of the set of discovery there at the beginning, that was completed. If there may be the need for a preservation deposition that hasn't been considered yet, especially given the change in the makeup of the party since then, or what's happened since then, since there are witnesses who are out of state. So that may be something that we need to revisit, but other than that, other than say stipulations or any other updates in terms of just minor things like that, things have been, all that's been kind of taken care of.
Okay. It sounds like this is a fluid situation given the other pending matters. And so I would encourage the parties to continue their settlement discussions, perhaps do another mediation, whatever the case may be, based on what happens in the other matters. So just some encouragement. But I'm looking to set a 4-day jury trial beginning on March 22, 2027. It'd be March 22 through March 25. Mr. Gibson, do you have your calendar in front of you? Does that work for you?
I am pulling it up right now. Yes, that works.
Okay, Mr. Marion, what about you?
Pulling up those dates.
March 22 through 25.
Correct.
I currently have no hard conflicts, so that's
Okay,
fine.
great. Okay, so that will be our trial setting. Of course, that will be an in-person trial. And we are looking to set the final trial management conference, which would also be in person, probably take about an hour. We're looking at setting that on February 19, 2027 at 11 o'clock a.m. Does that date and time work for you, Mr. Gibson?
It does.
Okay, great. Mr. Marion?
That also is fine, yes.
Okay, great. And because we use a digital or electronic questionnaire for the jurors, and we give them the option of completing the questionnaire in advance without having to come down to the courthouse to see if perhaps they might be excused, we need to set a preliminary voir dire hearing. That we can do virtually, and it usually takes about an hour or less to go through the questionnaires that have been submitted in advance. We're looking at setting that on March 19, 2027 at 11 o'clock a.m. Does that date and time work for you, Mr. Gibson?
It does.
Great. Mr. Marion?
Going back to March.